Welcome back to Primetime News, and if you're watching on onespotmedia.com, again, a very special welcome to you. Thanks for joining us. The Mental Health Offenders Inquiry Committee is recommending sweeping changes in the justice system to protect people who are not fit to plea. The committee was formed in the wake of the death of Noel Chambers, who died in prison where he'd been locked up for decades without being tried. The Mental Health Inquiry Committee presented its report on mentally ill persons and the justice system at a media forum Thursday morning. Committee chairperson Justice Georgiana Fraser noted that the challenges for the mentally disordered defendant begins at arrest and may extend for decades. There was outrage earlier this year following Noel Chambers' death in January after being locked up for 40 years without being tried because he was at times deemed unfit to plead. Justice Fraser says, from the point of arrest, intake protocols for mentally ill persons are not followed by the police. It then gets worse when they are brought before the court. The parish court judge is to determine if the person is in fact mentally disordered, which requires evidence, including reports from a psychiatrist.
Now, there are not an overabundance of psychiatrists within the public sector who are to perform these tasks, and this can lead to delays in the process of even determining whether the person is in fact mentally disordered.
But even when that determination is made, returning a sick person to their community or to roam the streets is not recommended, and so they are detained further, awaiting assessments on if they are deemed fit to plead. But Justice Fraser notes that even if they are deemed unfit to plead, several factors may lengthen their detention period. Lack of transportation to assessment sessions and court hearings, improper record keeping on the case, and locating family members in whose care they may be released. The committee has therefore listed several recommendations. Firstly,
there is a clear and pressing need for statutory revocation of indefinite detention, meaning we need to do away with indefinite detention.
They're also calling for the health ministry to designate an appropriate facility suitable for the housing and treatment of mentally disordered defendants. This would be in addition to the Bellevue Hospital. That all mentally disordered defendants being housed in correctional facilities be removed to a psychiatric facility, for the implementation of a court diversion program that would divert mentally disordered defendants out of the normal adversarial trial process, and for a revision of the legal test determining ability to plead to be reformulated by statute to focus on decision-making capacity rather than intellectual ability of the mentally disordered defendants.
Chief Justice Brian Sykes is this evening hitting back at attorneys who've argued that judge-alone trials will benefit the prosecution. Justice Sykes, who was speaking at a media forum this morning, said the claim that judges will be biased in favor of the prosecution in bench trials is baseless. Vashon Brown reports.
Since the pandemic, jury trials have been suspended to prevent further spread of the coronavirus. This has resulted in some trials being pushed back to 2021 or 2022. There have been mixed reactions in the legal fraternity, as many attorneys and clients are reluctant to rest their fate in the hands of a judge alone. Chief Justice Brian Sykes says he's heard the concerns raised by some lawyers who have argued that judge-alone trials are problematic because some judges will be biased in favor of the prosecution.
When you hear that kind of argument, you don't want to think intuitively that with bench trials you have a higher conviction rate than jury trials. But when you look at the actual data, that really isn't the case.
So what do the figures say?
In the circuit courts and the gun court, where you have bench trials, the conviction rate is 37%. With the jury trials, it's 46%. So this is why when we're having these kinds of debates, we need to actually inform the debate by information, by data. So it really begs the question whether judges are as biased as people suggest that they are.
He says the question is not whether the judge was previously a defense attorney or a prosecutor, but whether the judge has the mindset to be open, balanced, and fair.
It's an ongoing process of training So for us, the issue is not whether the judge came from a prosecutorial background or from some other background, but whether the particular individual has the attributes that would make that person develop into a competent and effective judge.
The Chief Justice also argues that no figures have been presented in this debate showing successful appeals on the basis that a judge is biased in favor of the prosecution. He notes that judges must give reasons for their decisions. That, he argues, is an essential part of the judicial function.
In the context of jury trials, it is actually based upon an assumption. The assumption is that over the period of time that the jury have been sitting in the witness box, they have in fact been following the evidence. That's the first assumption. The second assumption is that they understand all the evidence that they have heard. The third assumption is that they actually understand the directions in law given to them by the judge.
Justice Sykes says he's not arguing that one form of trial is better than the other, but outlining the court process. Vashon Brown, TVJ News.